friends, welcome to Law and GK. So friends, on this channel we discuss the contents of law and previous year papers of judicial services and other legal exams. So friends, in today's video we are going to discuss the preliminary exam paper of ODISHA Judicial Services 2019. So friends, if you are new on this channel, I would like to recommend कि आप जो है इस चैनल को जल्दी से सब्सक्राइब कर लीजिए because it will be very beneficial for you in your preparation for judiciary and other legal exams. And while subscribing, don't forget to press the bell icon so that you can get the notification for our upcoming videos. And if you like this video, just click the like button over there and appreciate this with your friends so that they can come to know about this channel as well. And अगर आपको हमारे efforts अच्छे लगे हों तो in addition to like and subscribe, kindly give us a super thanks. Super thanks is a way to help the content creator. Means if you like the videos, you can just donate some money to them in form of tips. Minimum starts with 20. Minimum is 20 rupees. So let's move on to the question paper. देखिए क्वेश्चन पेपर कुछ इस तरीके से आता है. This it mentioned here 2019 exam paper. Series A, serial number is mentioned. I have downloaded this paper from the ODISHA website. You can just download it from there. So time is 90 minutes and you have to solve 100 questions and 25% of negative marking is there. So question number 1 is, who among the following was the special PP in disproportionate asset case in which Tamil Nadu Chief Minister Jayalalitha was convicted for 4 years? It was Bhavani Singh. B is the answer. Next, 2. Government of India Act 1935 was a lengthy document consist of 321 section and 10 schedules. The statement is true. A is the answer. Next is 3. How many times the preamble of the Constitution of India amended? Once only, by 42nd Amendment. Next is 4. The first session of Constituent Assembly was held at Delhi. A is the answer. Other options are these. Next is 5. Which of the following article of the Constitution guarantees freedom to manage religious affairs? ये मैरिज नहीं है, ये मैनेज है. यहाँ पर ये उड़ीसा के पेपर में बहुत ही मिस्टेक्स रहती हैं. So many mistakes in Odisha Judicial Services paper. This should be manage religious affairs. That is Article 26B is the answer, but this question was deleted due to this mistake. Next is 6. Which of the following article about fundamental right is directly related to exploitation of children? That is 24. D is the answer. Next is 7. Which of the following article were amended to rectify the effect of Goloknath judgment? That was Article 13 and 368 both. D is the answer. Question number 8. How many items were there in 9th schedule when it was introduced? So this was also deleted. This is 9. Which of the following cases upheld the right against solitary confinement? That is Sunil Batra versus Delhi Administration. A is the answer. This is 10. Is judicial review a part of basic structure of Indian Constitution? Yes, it is. A is the answer. And it was held in which case? Indira Gandhi versus Raj Narayan, 1975. Next is 11. Degree has been defined in section 2.2. D is the answer. Next is 12. In the case of inconsistency between section and the rules, the sections will prevail. A is the answer. And where this is mentioned, and it is indirectly mentioned in section 128. It is mentioned that rules shall not be inconsistent with the provisions of the code, means sections. Next is 13. The body of CPC containing section can be amended by the Parliament. C is the answer. See, this is a tricky question. How? See, 122 and 125 section of CPC mentions that High Court can make rules, but that's subject to approval of state government, central government. See, but nothing is mentioned about the sections. The sections can be amended by the Parliament only. C is the answer. This question was also previously asked in Punjab Judicial Services. Next is 14. Civil proceedings instituted by presentation of plaintiff is called suit. A is the answer. Next is 15. Can a civil court pass more than one order in a suit? Yes, they can order. A is the answer. Next 16. The first uniform code of CVC was enacted in the year 1859. B is the answer. Next 17. The substantive part of the code of CPC. The substantive part of CPC is contained in sections. A is the answer. Next 18, is it necessary to state the amount of cost incurred in the suit? Yes, A is the answer. Only at that time you can ask reimbursement from the defendant. Next 19, can the court issue commission for the examination of person in prison? Yes, A is the answer. Section 75, order 26. Next 20, is it necessary for the court to pronounce judgment in all issues? Yes, totally. A is the answer. Next 21, section 2G of CRPC defines inquiry. B is the answer. Investigation in 2H. Next 22, in a warrant case instituted of police report, a trial begins when charges are framed. This is a mistake, so this question was deleted. After framing of charges, trial starts. But the trial starts in every case after the framing of charges. So this question was deleted, maybe due to that mistake only. So many mistakes in paper. Next 23, an illegality in the investigation does not vitiate the trial unless the miscarriage of justice has been caused. C is the answer. Next 24, identification of arrested person can be ordered by the court on the request of officer in charge of police station, and where this is mentioned, section 54A of CRPC. Next 25, every summons shall be served by public servant, police officer, officer of the court, any of them. D is the answer. Summons how served, where it is mentioned, section 62 of CRPC. Next 26, a warrant may be directed to any person for the arrest of escaped convict, proclaimed offender, and person who is accused of non-bailable offence and is evading arrest. All of them. D is the answer. Next 27, can the evidence of witness be taken on oath with the magistrate conducting an inquiry? Yes. A is the answer. Next 28, any court may alter or add to any charge at any time before the pronouncement of judgment. C is the answer. Section 216 CRPC. Next 29, what is the maximum sentence of imprisonment which can be imposed for an offence tried as summary trial? That is maximum 3 months. D is the answer. Where it is mentioned in section 262, and summary trial provision is from section 262 to 265. Next 30, can a witness refuse to sign a deposition if it is not read over to him? Yes, he can refuse. A is the answer. Next 31, which of the following type of evidence means testimony? Direct evidence only. A is the answer. Next 32, who drafted Indian Evidence Act? J.M. Stephen. D is the answer. Next 33, the Indian Evidence Act does not mention relevancy is there, admissibility is there, weight of evidence. C is the answer. Next 34, the word relevant is derived from the Latin term relevare, which means legally pertinent. B is the answer. Next 35, which of the following is not a public document? Order of a competent authority fixing price of commodities. This is a public document. Order issuing search warrant. This is also crop cutting report by collector. Yes. Plain donation statement. They are private document. D is the answer. This is a repeat question. Next 36, relevancy is a question of law. B is the answer. Law ही तो बताएगा ना कि which facts are relevant, which are not, as per the sections provisions of Evidence Act. Next 37, register is an exception to hearsay rule. B is the answer. Next 38, proof of a fact depend on probability of it having existed. B is the answer. Next 39, when one is unable to decide how the fact stands precisely, it can be termed as not proved. C is the answer. Next 40, the maximum falsus in uno, falsus in omnibus. Now see, this is a rule of evidence, but it is not a sound rule of evidence, because this rule is not applicable in India, because the meaning of falsus in uno is false in one and false always. So when somebody is false once, he cannot be presumed to be false always. So therefore it is not a sound rule of evidence. So the option is not there. D is the answer. Next 41, the principle of criminal liability, actus non facitorium nisi mensitria, is the origin of common law. C is the answer. Next 42, which of the following is not a sine qua non for making a person criminally liable? Mens rea is there, yes. Actus reus, yes. Motive, no. Motive is not necessary, so it is not sine qua non. So C is the answer. Next 43, which of the following is an inchoate offense? That is attempt. Inchoate matlab means incomplete. So attempt is not complete. A is the answer. Next 44, which of the following section of the IPC is added by the IT Act? That is 29A. B is the answer. What is 29A? Electronic record. It is after document. Next 45, loss of unlawful means of property to which person losing it is legally entitled. That is wrongful loss. And where it is mentioned, wrongful loss and wrongful gain, section 23 IPC. Next 46, the word electronic record shall have the same meaning assigned to them in IT Act. B is the answer. And अभी देखिए अभी हमने किया है, this is section 29A. Next 47, no court shall take cognizance of an offence punishable under section 153 except with the previous sanction of central government या फिर state government. C is the answer. And where this is provided in section 196 of CRPC. Next 48, in a prosecution of an offence of criminal conspiracy, the onus of proof is on prosecution. A is the answer. Next 49, which of the following is not a punishment provided under IPC? Which is not a punishment? Forfeiture property is there, yes. Imprisonment with hard labor, that rigorous imprisonment, it is there. Transportation of life is deleted, death is there. So C is the answer. Section is 53 IPC. Next 50, which of the following theory recognizes the principle of eye for eye, tooth for tooth? Retributive theory. B is the answer. Next 51, which of the following section of the Limitation Act gives an inclusive definition of easement? Is 2F. B is the answer. 2C is bill of exchange. 2F, that is easement. 2G is foreign country. And 2H is good faith. Next 52, which of the following section of Limitation Act defines period of limitation? That is 2J. It was not in option, so this was deleted. 2I is plaintiff. 2F, as we earlier discussed, easement. 2K is promissory note. 2C I already mentioned, business bill of exchange. The period of limitation extinguishes the debt, renders the debt, extinguishes the debt, and render it enforceable. Render the debts unenforceable means remedy is barred, not the right. B is the answer. Next 54, as defined in section 2I, suit includes. Suit is defined in section 2L. So this question was also deleted. 2I is period of limitation. So many mistakes in the paper. Next 55, an order made on an application filed beyond the period of limitation is illegal. A is the answer. Next 56, in a suit for recovery of possession of a house from a deemed trustee of Waqf property, Waqf pe no limitation applies. A is the answer. And where it is mentioned, that is section 10. It mentions about suit against trustees and means trust. Waqf is a trust, it's a trust property. Next 57, limitation runs from a date of order. Plaint is returned. Date of order depends. Date when the plaint is returned. So I would say this question should also have been deleted, but they are saying the answer is plaint is returned. So there are only two options: return or directed to be returned. The explanation of section 14 mentions that excluding the time during the former civil proceeding was pending, the day on which the proceeding started was instituted, the day on which it was ended, both shall be counted. This is a doubtful question. Next 58, which of the following section of Limitation Act deals with acquisition of easement by prescription? It's a repeat question, section 25. Next 59, the period of limitation for a suit for accounts and a share of profit of a dissolved partnership is 3 years. C is the answer. And where it is mentioned? It is mentioned in Article 5 of Schedule of Limitation Act and 3 years from the date of dissolution. Next 60, the period of limitation for the suit relating to decree and instrument is 3 years, C is the answer. And where it is mentioned? It is mentioned in Article 59 of Schedule of Limitation Act. Next 61, inter vivos means between living persons. So the options was not correct, so it was also deleted. Next 62, as per the section 13 of TPA, a transfer of property is valid in case of an unborn person if the interest is created for the benefit of unborn child. C is the answer. Next 63, subrogation in Roman word means substitution. So other options are here. This is so irritating. B and C. C is the answer. Next 64, contribution to mortgage debt in a transfer of property comes under section 82. A is the answer. Next 65, the definition of actionable claim was substituted by the amendment of which year? 1900. C is the answer. Next 66, to make the assignment of actionable claim perfect notice of debtor is not necessary. D is the answer. It is mentioned in section 130. It mentioned that whether the notice to transfer is given or not. Next 67, right derived to a mortgagee to obtain a decree for foreclosure in the event when the mortgage money becomes due. D is the answer. Next 68, the pendency of suit for the purpose of section 52 commences from the date on which plaint presented. A is the answer. Next 69, doctrine of holding out is related to transfer by ostensible owner. A is the answer. And where the provision section 41, election 35, in the grant of estoppel 43. Next 70, doctrine of election is explained in just mentioned section 35. A is the answer. Next 71, Indian Contract Act is not exhaustive. The statement is true. A is the answer. Next 70, the popular case of Askari Mirza versus Jai Kishore related to coercion. C is the answer. Next 73, which of the following right is are not available to the agent? That is right to sell. See, I found this paper very low quality. The people are not just checking it. So many mistakes, so many questions has been deleted, and here this is also not proper. Now not available to the agent in what sense? Means agent are trying to get his right to wages or something, so he can just compensate, retain, but he cannot sell. They shall have mentioned it properly. It is a very improper question. Next 74, a guarantee obtained by means of keeping silence as to material circumstances is invalid. C is the answer. Next 75, which one of the following is not a remedy for breach of contract? Damages is there, injunction is there, fine is there, specific performance. Fine is not there. C is the answer. Next 76, ये OZI नहीं है, ये quasi contracts है, are dealt in section 68 to 72. C is the answer. And sometimes they also ask the chapter. Chapter is chapter 5. Next 77, promissory estoppel is sometimes spoken of as a substitute for consideration. C is the answer. देखिए ऑप्शन में यहाँ पर here again OZI का रखा है, quasi contracts, quasi contracts. C is the answer. Next 78, the leading case of Balfour versus Balfour related to intention to enter into a contract. D is the answer. Next 79, an agency is terminated by a principal revoking the authority, agent announcing the business of agency, either a principal dying or becoming unsnap-mind. All of these 2 is the answer. Section is 201 of Contract Act. Next 80, which of the following section of Indian Contract Act deals with Bailey's particular lien? That is section 170. D is the answer. Next 81, which of the following section of Hindu Succession Act deals with the properties to which act is not applicable? That is section 5. A is the answer. Next 82, legacy means a gift of property by way of will. A is the answer. Next 83, by the amendment of 2005, section 6 of Hindu Succession Act was substituted. B is the answer. Next 84, in order to attract section 14 of Hindu Succession Act, the possession of property may be actual or symbolic, constructive, any. D is the answer. Next 85, according to section 10 of Hindu Succession Act, the interstate's widow shall take 1 share. A is the answer. On how many shares she will take? Section 10, you can see for that. Next 86, coparcenary is a narrower body than joint family. The statement is true. Yes. Next 87, general rule of succession in the case of succession of female Hindus are dealt with under section 15. D is the answer. Next 88, life estate granted to a Hindu woman by a will also become her absolute estate. The statement is true. A is the answer. Next is 89, when two persons are related by blood adoption wholly through males, they are called as agnates. It is defined in section 3A of Hindu Succession Act. Next 90, the property mentioned in section 14 does not include Stridhan property. This statement is false. B is the answer. It includes. Next 91, specific relief is a form of judicial redress. This statement is true. Yes. Next 92, the remedy of person unsuccessful in a suit under section 6 of Specific Relief Act is to file appeal not available, denied in section 6 itself. Review is also not available, revision not available. So regular suit establishing its title to the suit property. D is the answer. Within 12 years. Next 93, section 36 of Specific Relief Act classifies injunction into 2 categories. Next 94, which section of the SRA deals with effect of declaration? That is 35. D is the answer. 34 में डिक्लेरेशन के लिए सूट है, 35 में उसका इफेक्ट है. 36 प्रिवेंटिव रिलीफ कौन कौन से? टेम्परेरी एंड परपेचुअल. हाउ ग्रांटेड? परपेचुअल, टेम्परेरी. 37. 38 is for perpetual injunctions. Next 95, which of the following is termed as converse of specific performance? That is rescission. B is the answer. Next 96, can the court award compensation in case where the specific performance is impossible? Yes, obviously A is the answer. Next 97, which of the following section of Specific Relief Act deals with the power of court to award compensation? That is 21. C is the answer. Next 98, the Specific Relief Act grants specific relief only या फिर preventive relief also? Preventive relief also there, so both. C is the answer, both A and B. Next 99, which of the following remedies is provided by SRA regarding contracts? That is B, specific performance. B is the answer. Damages is not there for contract damages. You can see section 73, 74 Contract Act. Next is 100. The specific relief was result of the which law commission? See, this question is also wrong because the options are not correct. This was the 9th law report of First Law Commission. Alright, and First Law Commission was under MC Setalwad. So they gave the report on the Specific Relief Act 1877 in 1958. Alright, and the Bail Act only provides the information of 9th law report in the introduction. They do not provide any information regarding which law commission was that. So it was a First Law Commission and the 9th law report. Alright, so they submitted their report in 1958 and 1963 this was enacted and enforced. सो फ्रेंड्स, यहाँ पर हमने प्री एग्जाम पेपर ऑफ उड़ीसा जुडिशियल सर्विसेज 2019 का एग्जाम पेपर पूरा डिस्कस कर लिया है. अगर आपको इसमें कोई कमी लगी हो, कुछ सजेशंस और कोई एडवाइस हो तो आप कमेंट सेक्शन में जाकर भी लिख सकते हैं. वी ऑलवेज अप्रिशिएट योर कमेंट्स एंड फीडबैक. And friends, if you like the efforts, kindly give a super thanks. Super thanks is a way to help the content creator. Means if you like the videos, you can just donate some money to them in form of tips. Minimum starts with 20. Minimum is 20 rupees. And अगर आपको वीडियो अच्छी लगी इसको जरूर लाइक कीजिएगा. And don't forget to subscribe our channel. And while subscribing, don't forget to press the bell icon so that you can get the notification of our upcoming videos. So friends, thank you. Thanks very much for watching this video. Thank you.